We can start this session about a very challenging topic, that is the topic of how to make the regulation, the GPDR, work in practice. So there is a lot of work done at political and legal level, and then the regulation will trickle down into the practice, and it is certain that this will raise another enormous range of challenges and difficulties, because the regulation has to be implemented, and this has to be done with a foresight, actually, to what judges and DPAs will decide in each issue of application. So implementing is a particular style with a lot of difficulties involved. And to discuss these issues, we have a very beautiful and impressive panel. Our first speaker will be Gerrit Hornung. Gerrit Hornung is a professor. He has been a professor of law for a long time in Passau, but now he left for the University of Kassel, where he teaches public law, IT law, and environmental law. He is a specialist, and many of us know that he is a specialist and a recognized authority in the field of privacy and data protection law. Our second speaker will be Timothy Kirkhope. He is a member of the European Parliament. He has been the leader of the Conservatives in the Parliament for a long time already, and his focus is on justice and home affairs with a lot of attention for surveillance, cybercrime issues, border control, immigration, and indeed also data protection. The third speaker will be Florence Raynal. Florence Raynal works for the CNIL, the Comité National Informatique et Liberté, and has done a lot of work in the Article 29 Working Party. She is the head of the Department of European and International Affairs of the CNIL. The fourth speaker will be Karolina Mojzesowicz. She's linked to the legal service of the Commission, and she is head since December 2014 of the department, the sector concerned with the reform of the Data Protection Directive in DG Justice. And the last speaker is Brendon Lynch from Microsoft. He is the Chief Privacy Officer of Microsoft, now already for 12 years. He has, from that position, a global responsibility of implementing Microsoft's privacy policies, and it is very interesting to have someone with his profile in order to discuss the implementation of the GPDR. I'm not going to use the time more than necessary. Each speaker has 10 minutes. We will follow the order I proposed, and after the interventions, the floor will be open and the discussion will be introduced and led by Wojciech Wiewiórowski, who is the assistant EDPS and who was former Inspector General in the Polish Data Protection Authority. So the first speaker is Gerrit. Please take the floor.
Thanks a lot for the introduction, Serge, and welcome everybody from my side as well. I would like to focus on a few ideas and share some thoughts with you on the smooth transition of the from the directive to the regulation, and actually to the operation of the regulation. So my main point, or probably everyone's main point here on the panel, is that Brussels has now done its work, and now others have to work, and they have actually to work a lot, I guess. Others are legislators of the member states, even though we are now faced with a regulation because there's so many explicit and maybe even some implicit competences for the member states to regulate. So we'll not talk about courts here, but courts will have to work a lot as well. And the problem there is that new laws clarify some things and new laws open up lots and lots of new questions. As Jan-Philipp Albrecht has put it in the morning, that's not something specific about this regulation, but nevertheless it is a problem. I will focus on 2 points, and the first one is the problem of harmonized but still vague provisions, and the second one is the issue of the remaining competences of the member states. So first issue, we need to clarify some of the provisions of the directive and particularly those of the regulation, and particularly those who look very similar to the former directive. So the first question is, which of the provisions actually need clarification? And the answer to that question depends actually on your legal background. Because as a German lawyer, I'm very much used to very specific, sometimes people say too specific legal provisions. Others may find this rather disturbing because they're used to the fact that courts, administration bodies, DPAs, who else sort of clarifies these rules. I will exemplify this from a German perspective by comparing Article 6 of the regulation with what we have in Germany at the moment. So for the private sector at least, Article 6 looks pretty much like Article 7 of the directive at the moment, okay? So we do have performance of a contract, vital interests of the data subject, legitimate interests of the controller, and so on. So what interests are legitimate? We hardly find anything in the regulation itself. We do find some words in the recitals, for example, on marketing, but we don't have that much. Okay, so at least in Germany, we do have very, very specific provisions on this respect for marketing, for market research, for address trading, for credit agencies, and so on, and so on, and so on. Okay, so just to give you an example, I counted the wording of those specific provisions in what we have in Section 28 to 30A in the German Data Protection Act. And this comes down to some 2,500 words of statutes. Okay, and so even if you sort of take away the over-ruling or over-regulating German approach to data protection, that's about 10 times more words than Article 6 has, okay? And so from a German perspective, these very specific, very clear rules are just stripped off us, okay? So they're taking away from us. So what are we going to do now at the moment? And I believe that this is a moment of uncertainty. So from a national perspective, we're faced with a directive, from a German perspective, we're faced with a directive in the form of a regulation, at least in Article 6. So we need common interpretations. How do we get them? Well, we do have the European Data Protection Board, who will be able to issue opinions, guidelines, recommendations, and best practices, but they're largely not binding on the member states' courts, okay? And on the contrary, they will be subject to judicial review. So what DPAs and courts on the national level are going to do? Well, some practitioners may follow what I call the stay calm and carry on approach, because they might have the feeling that they are left with less specific rules and may feel the need to apply the former rules, former national rules. So, for example, Article 6 contains the concept of legitimate interest and the weighting of interest with a data subject. So criteria for this weighting of interest were provided in former national laws, those sections 28 of the German Data Protection Act. So it's very easy to say, well, criteria for this weighting of interest were provided in the former law, and those criteria are so compelling that we are now actually applying them under the regulation. Okay, that's very, very easy things to do, and I have a safe guess that's exactly what some, at least DPAs and courts, are going to do. So to close with this first point, in any case, I think we will need to discuss the relationship between the new hard laws of the regulation itself and the member states' laws, and the soft laws, which most notably are going to come from the European Data Protection Board. So opinions, guidelines, recommendations, best practices. So I think this relationship will be crucial for the implementation process. The second issue, clarifying the remaining competences of the member states, because member states need to react in several ways. we need to clarify which national laws remain in force and where there are additional provisions needed, because we have opening clauses and some of the provisions of a regulation are not able to put in practice without national laws. Substantive provisions as well as procedural provisions as well. And then we also have all these optional provisions, age for consent in the internet, complaints by non-profit organizations, and so on and so on. So it all comes down to opening clauses. And I discussed this with colleagues, and depending on how you count, we probably have between 40 and 50 opening clauses. Most notably, Article 6, paragraph 2a and 3. And I think we're going to see very diverse views in the member states on the content of Article 6, paragraph 2a and 3. Unless we don't have common views on the broad of these opening clauses, we're not going to get to any sort of harmonization, I believe. There is at least just one last view to share with you, an important question which actually reaches beyond data protection law and the regulation. If we are faced with cases of regulations which actually use wordings of directives, so what does that mean for member state competences? I mean, the case is clear if they're explicit opening clauses, but if there are very vague provisions which need specifications to be put to work, would there be such a thing as implicit opening clauses? At least in Germany, we're starting this discussion, not for data protection, but for other directives, for other regulations. For the regulation, some of the provisions need specifications, and the Commission's proposal wanted to solve these problems through delegated acts. So in the trilogue, very, very few of these remain, which I personally welcome, but the outcome falls short of telling us who else has the power to provide us with specifications, with binding specifications. We do have these opinions and so forth, but will there be such a thing as implicit opening clauses? I think this problem needs to be addressed, at least as I said, in Germany, we're starting this discussion. I leave it there. There are a lot of specific issues necessary to address to make the regulation work, but I felt that we need to clarify these two rather fundamental points. Thanks a lot.
Thank you very much, Gerrit. The next speaker is Mr. Kirkhope. Please take the floor.
Thank you very much indeed. Can I just start by saying that this has been a long process as far as the European Parliament is concerned. And I think really we've gone in the last few weeks and months from a question of will we get a deal at all, now to what is the deal, and then what does the deal really mean on the ground in implementation. Because, of course, one of the greatest concerns I've had all the way through has been the question of implementation. It's a topic that matters here. And, of course, it's the same in all policy areas that we deal with. It's the same with the single market, with immigration, with security. We can adopt as many well-thought-out laws as we like, but unless they can be implemented effectively and advantageously, then that activity will have been pretty pointless. I supported the final outcome of the regulation. I believe in high data protection standards, and I believe that trust in our online services particularly will breed consumer loyalty and investment. In many ways, I would have preferred, however, to see a regulation which was simpler and more principles-based rather than so prescriptive. And that, of course, again, is why implementation will be central to whether or not it works well. The Commission, data protection authorities, and the EDPS need to start issuing advice and recommendations on how best to make companies and bodies compliant and poised for the entry into force of these provisions. The data protection package has been a long time in the making, and the hope is that much like a fine wine, the time, effort, and lengthy considerations will create a better finished product. But I think we ought to be frank. Many companies are currently operating under a regime which was designed for an era that was dominated by the pen and not the smartphone. Large companies will have the resources and expertise to address the implementation challenges, but smaller companies will find it more of a challenge, and there needs to be plenty of support there for them. Understanding the nuances of the regulation and the principles and aims behind it will be key if local, national and multinational companies are to capitalize on the opportunities which the digital economy and the simplified legal regime and the regulation can offer them. In theory, of course, the regulation presents a level playing field of data protection law, providing also opportunities. Opportunities to market your company abroad, opportunities to attract foreign investors, as well as an opportunity to increase consumer trust in a world of individuals who are conscious of their digital footprints and the safety of their children online. A stronger data protection regime will also mean data collected will be more accurate and of a higher quality, and that's essential to harness the potential of big data in the world of smart products. During the last few years, working on the regulation, there have been many evaluations and assessments of the impact. Small and medium-sized businesses have been found to be the largest growing sector during our economic recovery, and we must make sure that ability to grow and innovate is protected rather than stifled by new requirements. The UK ICO identified 4 main areas which businesses were most concerned about and were likely to cost them more. First of all, the higher standards for obtaining consent from data subjects, the strengthened rights of data subjects to access their personal data and the right to deletion, the stricter obligations of data controllers to provide information to individuals and notify of breaches, and punitive administrative sanctions that authorities are required to impose in the event of non-compliance. Whilst the initial estimated savings for businesses calculated by the European Commission was wildly overestimated at nearly £2 billion, that is, there is a genuine point to be made that small and medium-sized companies can benefit from operating under one clear single regime rather than having to interpret the legal demands of 28 member states and their data protection authorities. Such clarity could potentially help small and medium-sized companies reach beyond the shores and seek profitability and growth elsewhere, whereas the 1995 directive applied its rules and obligations equally regardless of business size. The new regulation does at least attempt to reduce red tape for SMEs. So preparations for business are necessary. Businesses don't need to wait until literally midnight the day before the regulation comes into force to do something about it. So they should now be organizing their privacy policies, procedures and documents. They should create a breach notification process and enhance the incident management processes and detection and response capabilities. They should appoint a data protection officer, take time to understand that role in particular, understand the principles and the operations behind the right to be forgotten, the right to erasure, and the right to data portability. And they should start creating a culture of data privacy within the workplace by reflecting a workable and proportionate interpretation of privacy by design. Small and medium-sized businesses need to do the same by assessing if their business already complies with existing data protection regulations. And if not, they should make plans to do so and seek advice. If the right principles and procedures are applied from the start, it will be easier to do more with the resources and expertise already available at a lower cost rather than trying to fix problems at a later date. Too often when new regulation is introduced, it feels as if individuals, businesses, the courts and legislators are feeling their way in the dark on the issue, and I think this time that can be and should be avoided. But of course implementation is not enough on its own. Not if the regulations to be a success, it is about creating a European culture of data protection and what that means. The European needs are clearly a skilled and informed workforce, confident in data, math, and information technology, tools and infrastructures capable of storing and analyzing data, and the ability for consumers, businesses, and academia to access and share data appropriately, for there to be a technical capability for us to share data sets from different sources and to recognize their value, as well as developing cloud computing. Too often individuals ignore notices, often don't understand the choices and resist acknowledging them, ticking them or reading them unless compelled otherwise. We need to make sure that analytical skills are placed at the forefront of education for schools and postgraduates, as well as in-house training. And these skills should be encouraged at every level of business, not just in multinationals, but particularly, as I have said, in small and medium-sized businesses too. Finally, I believe that if we can preserve key principles such as legitimate interest, proportionality, and technological neutrality, then this regulation will hopefully be able to serve businesses and consumers effectively for some time. But I'm an advocate of what I call smart legislation. We don't have it. We probably never will. We are now revising 1995 situation. In the United States, Congress has yet to revise a 1975 set of protective regulations in relation to this in this field of data protection. We can't keep up. We have to keep up. So we as legislators need to devise new ways of doing so. Smart legislation, ladies and gentlemen, is almost as important as smart everything else. Thank you.
Thank you very much. I think we will have some discussion. The next speaker is Florence Raynal. Please take the floor.
Thank you very much, Serge, and hello to everybody. Thank you very much to the organizers for inviting us. We are very pleased to be here and to share some thoughts on the concrete implementation of the regulation. First of all, maybe to stress that, at least for those that are in the room, it's a very historical moment that we are living right now. We are about to change a framework, also a philosophy. It will be a drastic change for everybody. I mean, for DPAs, and I will talk a little bit about how we envisage the implementation from a DPA point of view, but of course it will be also a big change for the business in the way they handle their privacy culture. I agree with you, it's about a change of culture, and also for, hopefully, for the individuals, for the data subject. So now the question is not really about the principle and what is in the regulation, and whether we like it or not. It's really about how we make it work and how we create a success based on this text. So really the idea, and it's a very positive spirit from the data protection community, the data protection authority community, it's to make it work in an efficient way and in an effective manner with results. So maybe I will give you some flavor of the discussion we had between us at the working party level on the way we envisage this implementation at a European level, but also I will give you some insight about the CNIL strategy for implementing the regulation. So I thought that it was interesting to have both sides, so European level, but also the experience of one DPA, the one that I know the most, the CNIL, and to see how a DPA will adjust itself to this new context and this new framework. So for DPA, it's really a turning point, because we will change our way to work at 3 different levels. The first level is, of course, the EDPB level. As you know, today we are working under the Working Party 29 umbrella, but tomorrow it's the EDPB one, and it's a different one. It's another dimension, and I will elaborate a little bit on that. But so we have also to change the way we work at the European level. We have also to change the way we work between us at the layer of the one-stop shop. So how do we, concretely speaking, on a daily basis, we work together between DPAs on concrete cases, on cross-border cases. And that's a very important layer. And that's the one where we also need to be very efficient. And the third layer is the national layer. So the national layer, of course, is maybe a little bit different because it's a national one, but as you rightly pointed out, there are very strong connections between what we do locally under a national law in the future and what we will do at a European level. The idea of the regulation, and that's why it's a regulation, it's to avoid divergent views as much as possible. And that's really something that we have taken into consideration at CNIL level, is that now we cannot issue any kind of doctrine we want with respect to the regulation. We will have to be consistent in all things that we issue with respect to the regulation, because it can impact the others. So there is a very integrated way also, not only on enforcement, but also on doctrine. So, to be a little bit more precise about the change. So at the Working Party 29 level, so today, I mean, the Working Party 29, as you know, is the kind of advising body to the European Commission. We are also producing guidelines on any kind of matters that touch data protection. But it's really, you know, about guidance to the public, to the business, but it's not binding at all, and it's done in a way quite informally. Tomorrow, with the EDPB, it's a total different dimension. The EDPB is a legal body of the Union, so it has legal personality and can take binding decisions. So just from a purely legal point of view, it's a total different manner to work, and there is now a real statute for this community body. Of course, we will continue to issue guidelines, but the guidelines, I guess, will be a little bit different in the implementation, in the sense that, again, the idea is to be very consistent in the way we interpret and we apply the regulation at the national level. And I guess, as you rightly pointed out, there is one aspect about what will remain at the national level that will be important to tackle. In order also to have as much as possible a consistent point of view on HR and health information. The EDPB will also take the binding decision in case of disagreement between data protection authority. So that's also totally new. It's a totally new system for us, so that's also something that we need to organize and to make it work. It's a new area. There is also another point I want to raise, is the calendar. The calendar is very important. I mean, we have 2 years, a little bit more 2 years to implement that, but we have to be ready on day one, approximately in 2018 first semester, to act as EDPB. So the clock is ticking. We have to be ready on time. And there is another aspect, is that we will have to cope with different systems for 2 years during this transition period. So there is, of course, the regulation, but still the directive. And that also will be a difficult period for national DPA to cope, and also for the Working Party 29 to cope with 2 different systems at the same time, continue to apply the current one, but to anticipate the new one. So on the EDPB level, we have already started to work on it at the Working Party 29. Next week at the plenary, there will be a discussion on an action plan that was drafted by the presidency and the vice presidents of the Working Party 29, also with the help of the EDPS, in order to provide some priorities for 2016 and also concrete deliverables. So it's really a plan on how we get organized and what we produce in 2016 in order to be ready to anticipate and digest the regulation. And the proposition are quite diverse. And there is a very interesting one that is about the EDPB itself, and how do you create a legal body? There are a lot of questions and discussion around how, you know, for example, a very, very concrete thing about translation, about meeting rooms. I mean, we are changing our environment on SLA with institution. How do we make this EU body work? How do we create that? And that's a very, very interesting part. Also about the IT system of the EDPB and of the one-stop shop and the interface with the national system. That's also a very, very important element. We have to get some systems, some very practical system to make this thing work. There is also a lot of proposition about, you know, the guidelines to you, guidelines to controllers and processors. What are the priority, the most important one? What do we do first? So how also to get organized on that? And as I said at the beginning, there is also the mediation, arbitration part between DPA that also need to be worked on, because it's not that an easy part to do. Last thing, it's about communication. How do we communicate about the EDPB? Even if we are in a transition period, the EDPB will be soon the new body. So we need also to anticipate on the website and also on the way we identify, we make this body identifiable. So that's the layer of the EDPB that is, as you see, is also quite ambitious. And there is another layer that is the one-stop shop. And that's also part of the action plan of the Working Party 29. It's also to start to think about the way we will get organized together in terms of process, of mechanism, of guidelines, also of templates that we will use. So it's very practical, very concrete. So for example, like how do we manage complaints together? As you know, in the regulation, there is a distinction between purely local case. You have also cross-border case for complaints. And so that's not necessarily easy to do in a very, I would say, concretely speaking. So we have also to see how we organize this management of cross-border case. Also about joint investigation, also about sanction procedure. How do we decide together on the one sanction? So there are a lot of things also about confidentiality. How do we exchange information? How do we define a cross-border case? So there is a lot going on and a lot of documents, I guess, that we will need to issue in order to make this thing run. And the last thing is the national level. So that I would talk about more the CNIL experience because I'm not necessarily familiar with the 28 action plan for implementing the regulation. But for the CNIL, it's a big change of philosophy. It's a new paradigm in the sense that, as you may know, the CNIL was very focused on the administrative filing. There was a big part of the CNIL that was about administration. This is not anymore the case. So we will have also to rethink the way we are organized. And what we did is that we organized a workshop with the 200 employees of the CNIL in order to consult them on the way they see the implementation of the regulation for them in their job, in their daily job, because there will be change also in terms of job at the CNIL. So we are reorienting our business model, if I can say that like that. And we will Europeanize, I don't know if it's a good word, but we will change our process to get more European. And that's to be very concrete, we will have English lessons for everybody. So that's, I would say, not maybe the most important, but it's still a very important piece. But also we are changing our procedure, our mechanism in order to cooperate for each type of I would say, of sector and also of field. The complaints team, the enforcement, the investigation team, the one that are dealing with sanction, the accountability team, everybody now need to cooperate at a European level because we will need to decide together. 28, we need to have joint decision together. So it's very important that also at the national level we feel European. So it's a very important also change for us. We are also dealing now with the law, the change of the law. So that's also very, very concrete. We will have some working group with our government in order to draft the new law to help, to advise on the drafting of the new Loi de 78 that will also need to be updated according to the regulation. So, just to finish very quickly, on est en ordre de marche. I don't know how you say that in English, but we are working hard to be ready in 2 years, a little bit more than 2 years' time, to, in fact, to be with you, to help you, and also to make this regulation working. We need to create for sure legal certainty, so that's why we need to issue as much as possible guidelines to you before, in order for you to be ready as well with us. Thank you.
Thank you very much. After the voice of the Academy, the Parliament, the DPAs, the voice of the Commission. Karolina, you have the word.
Yeah, thank you very much. So maybe I'll start with what did we want to achieve? Why the reform? And here we had 3 aims. We were pursuing 3 aims, and then I'll present them, and I will try to convince you that we achieved all of them, all 3 institutions. So the first one, rationalization and simplification. And, pardon? Rationalization, it's better now. And simplification. And here Indeed, it's much better. We do not have 28 implementations of one directive, but we have one regulation directly applicable. This one is better? Ah, yeah, perfect. So the three aims, three objectives which we were pursuing. First one, simplification, rationalization. And during the process of preparing our proposal, we were very much aware, and the consultations showed it very clearly, that everybody was complaining about the fragmentation of data protection rules within the European Union. We didn't have one law, we had 28, with all costs for all possible stakeholders which were connected with it. Now, did we succeed? Already on this panel we heard that not enough, because we are not sufficiently precise, and that we were over-prescriptive. So probably we were somewhere in the middle, and taking into consideration that it's a very horizontal piece of legislation, touching upon almost all areas of our activities nowadays, I think we achieved quite some things. Yeah? And let's not forget, it is still a regulation, it's still directly applicable, and an individual can still invoke its rights stemming directly from the regulation in front of the national courts. Now, the second element, update of the rights, adjusting rights of the data subject to the new digital age, and adjusting them also for the businesses. From my point of view, I mean, of course, I will be here very positive, but I think the three institutions did quite some good job. Businesses will have more legal certainty. We will have one-stop shop. We will have one set of rules applicable to all actors active on the European soil, yeah, within the EU, also non-EU companies. And the regulation is technically neutral and future-proof. This is the whole idea of data protection by default and design, open for the controllers, for the businesses to invent, to adjust to the future developments and to the needs to protect data in means, in ways which will be developed in the future. So I think this is also some opening which is then not over-prescriptive, because it allows us to keep on adjusting in the future, but on the other hand, yes, leaving it, moving from ex ante to ex post, puts the ball a little bit more to the controllers. You are responsible for what is going on. You know what you are doing, so build in a set of data protection rules as early as possible so that finally human rights, fundamental rights, are being protected. Now, from the point of view of individuals, this here element of interdependence also of the regulation was supposed to achieve, I think, to very big extent, we are very successful, and the regulation will give a big push will empower data subject, will allow them to feel more comfortable in this new digital age, so that they will more freely move in internet and will try to take advantage of all the future solutions which businesses will offer. So here this virtuous circle in interdependence between more empowered and more digitally curious consumers and businesses which are trying to match this curiosity and take advantage of it. Your right to be forgotten, clearly spelled out, the clearest spelled out and beefed up. Right to know when the data has been hacked, the whole story about data breaches, and of course portability. And here this is also opening and adjusting. This is giving a push to SMEs. This is allowing them to take advantage of freely moving consumers who within a second can move their data from one service provider to another one when this another service provider assures them, for example, higher data protection. So how it all will work, I think here what Florence was explaining before, to big extent this harmonized and unified application of the regulation will depend on the European Data Protection Board, which is actually cooperation between data protection authorities. And yeah, we, the Commission, will be a facilitator there. It's a very new way of cooperation. It's not a classic Brussels-centered means of harmonization of the application of a certain area of law. It's putting it back on the national level, but providing for a platform of cooperation which assures harmonized approach in this area. So yeah, challenges, probably there will be some, and one of the biggest challenges from my point of view will be precisely to assure that the board works effectively and is able and is really using all these powers which are given to it. But yeah, let's hope that within 2 years and a little bit, we will be able all to enjoy the new or clearly spelled rights which the one single act, the regulation, is providing us with. Thank you.
Thank you very much. And how does this fall in the ears of our last speaker? It's a voice from a very big global corporation that will be confronted with the implementation of the results of all this work.
Thank you, Serge, and thank you to CPDP for the invitation to come here and speak to you. And yes, I'll be speaking from the perspective of a large multinational who of course has to address and think about what implementation means inside an organization and how our existing privacy program and approach and culture and everything gets updated for these new requirements. And you know, I think I'll start by saying that we know these things are challenging to create. And as already been pointed out, there's probably a lot of laws around the world that are in need of an update for the modern times, and so we certainly commend the Europeans for being able to get this monumental piece of work done, to get this update in place. I think for us, you know, the way we look at it, it's still early, but there's some things that will be relatively easy for a company like us, and then there will of course be some challenges as we think about, you know, the implementation internally. I think for us it's partially, I say, easy because it's building upon an existing program. You know, we've been focusing on a comprehensive privacy program at Microsoft for over 15 years now. It started well before I got there. And it has evolved over the years and really embraced the core principles of accountability and a risk-based approach and the like, to the point that we now have about over 100 full-time privacy professionals embedded around the company doing privacy reviews every day on our products and services and business processes as they evolve. So in many places, it's about updating that for these new requirements. From the security perspective, we know, you know, certainly as a major cloud services provider with literally millions of organizations leveraging services like Office 365, we truly understand the need for best-in-class security, and we have significant investments there as well, as many other companies do. I think that, you know, one thing about risk, there was discussion earlier that, you know, the risk-based approach, many companies might think about risk to their company more than they might think about risk to individuals. And just to say a little bit about that and how I think that's certainly not true for us, and I know for many other companies as well. In fact, I see a direct alignment between the two, because if we know that in this new world of technology, of cloud adoption, of data being a key driver of innovation, that if we don't have the trust of our customers, we don't have a business. We know that people will not use technology they do not trust. And so there's actually a nice incentive aligned, I think, that if we're managing the risk of our customers, we're by default managing risk to the company. And and of course, all of the activities we have in place to do that also certainly help with compliance with places like the European regulations. So turning back to GDPR for a minute, we're in this transition phase, and I think what it's important to do is keep a couple of things in mind. First of all, the core principles of technology neutrality and the like that have already been mentioned, and that this ultimately does have a goal of simplification for business and enabler of the single digital market, that those core principles are kept in mind as this next phase of setting requirements and rulemaking comes in place for it. I haven't read the regulation, I haven't memorized the regulation word yet, but I understand that there are more than 50 references to national laws, and there's a lot of places where various bodies, the board, the DPAs themselves in some cases, do get to define things further. And so, what I would say from a practitioner standpoint, we certainly do not feel like we've got legal certainty yet. In a lot of areas we do, but there are still a lot of areas where legal certainty is yet to be defined to the degree necessary to be confident about changing your operations or your procedures in a certain way. One of the concerns I have, and just reflected on this conversation on this panel as well, is that in some ways we're needing clarity to come from for example, the board that has yet to be put in place, but we kind of need the clarity before it's even in place. So there's a challenge there, and that it may seem like 2 years is a long time, but for the scale of operations we have and the types of products and services we have, there's a fairly long lead time needed to make changes and deploy them on a global basis. So that's sort of one try and, I guess, create a sense of urgency, is that where there is still a lack of clarity, we really do desire that in a timely fashion in order to be able to be ready on day one ourselves and feel confident that we're in compliance with the new regulation. And I guess consistency is a key goal along the way as well. The other final point I'll make, I think, before we transition into the conversation side of this, is that to not also lose sight of the international scene. I think that there's a lot of work that's obviously going to be done here in Europe. I feel like there's been a lot of good progress over the recent years on an international basis. For example, regulators spending more time with each other, working out how to do enforcement across borders would be one example of that. Looking for ways for the different legal regimes around the world to better interoperate with each other. And so that work needs to continue. Increasingly, as we know, increasingly data flows are global, but privacy law remains local. Just to give you a sense of what the global scene looks like for us, there's now over 140 countries that we operate in that have privacy or data protection regulation that we need to take into account with our program. So, 28 of those are here. So it's great that you're getting harmonization across that. But there's a lot more that people like myself and others in industry need to take into account and work with. And the realization, of course, is that data is flowing across boundaries. We need to find ways. There is some urgency, obviously, with current situations with the demise of Safe Harbor, but we believe that that's an opportunity to actually solve this in a more comprehensive way going forward, more broadly. And for example, one of the things that we've been talking about after the Safe Harbor decision is really making it clear that we think the solution ultimately lies with as people's data moves across borders, that their rights move with the data. And of course that may seem, of course, very obvious to Europeans, but it's not necessarily the way that things are operating today. And I can go into it if anyone wants to, but we actually have a case right now where we're challenging a warrant in New York, which is where the US authorities are trying to seek access to data of a non-American, and the data is in our Dublin data center. And we are resisting that quite strongly because we think that's an overreach and it's an example, yet another, I think, pressure point, an example of why we really need some new legal frameworks on an international basis at the same time as we're introducing these new legal frameworks in regions like Europe. Thank you.
Thank you very much. You have been an exemplary panel. All speakers have respected the time slot. Wojciech, you are supposed to be a moderator, but I want you to be a facilitator before.
Well, to have the conference which lasts 3 days and have 75 panels, and some of them have 75 minutes like this one, is a very, very analog approach to what we may say the share of the knowledge. So I would like to ask the people in the panel to be a little bit more focused on the communication which is popular at the moment, and try to invent one tweet that would pass the most important message from you to those who are thinking about the practical solutions in the nearest future. So can you do in 140 sounds the main message that should be tweeted about the practical challenges that we will face in next 2 years? Can we start?
Well, that's a tough one to start with. I'm an academic. I refuse to do that, actually. I can throw words at you if you want. The first, I try to do that. First one would be member states' competences, as I said. Second one would be clarifying things for all sorts of different data processing situations, CCTV, whatever. The third one would be solutions for global data flows. That has just been mentioned by Brendon. And let me add one more thing, and the last one is information. Information flows on this regulation. I think that hasn't been mentioned yet. We need information because every single court decision of lower courts in whatever member state now are now being relevant for the interpretation of this regulation, and I think we need some sort of information system, some database to make sense out of this, what's going to happen out in the field there, because even big member states like Germany are not by itself some at the moment.
Thank you, Mr. Kirkhope. You made one text out of 4,000 amendments that went to the Parliament. So can you do it also out of the 10-minute speech?
Well, I mean, you're asking me what I think. You're asking me whether I think the most important thing in terms of the delivery and.
Yeah, the challenges for the nearest 2 years in implementation of this regulation.
Yeah, well, the challenge is actually to get the public, get the people perhaps who are not immediately involved in the implementation even, to get the public to fully understand the benefits of this and to try and minimize any disadvantages or inconveniences which undoubtedly it might provide, to give them full knowledge of their rights, as well as to assure them that it is being done for their best interests, to protect them, but also to make sure that the normal life they want to lead, the business life, the life in relation to data, and the use of data, is not going to become for them so complicated that they will begin to be rather negative about what we've been doing.
Thank you. Florence.
Thank you. Well, I was thinking about a picture, in fact. I was thinking that we have
That's
a kind
good solution. So you are attaching the picture to it.
It's the first step. That we have a kind of a drawing, thanks to you and to the Commission and also to the government. So we have a drawing, and now we have to put the colors inside. And we have to get organized and have an harmonized set of colors. So that's the most difficult thing. And I would say that, in fact, to add to what you say, it's a kind of collective solution. We have challenges, collective challenges, and we have to find a kind of collective solution in a way that we are not just the DPA, or now the supervisory authority, as it is written in the text, are not the only one to find a solution about legal certainty. And so, of course, we have a role to play, but I agree with you, there are other stakeholders in the ecosystem. There is the public, the data subject, the individual. There is also the business, and I think we have to work also to be partners on that field and to work together on how we define also the guidelines. For example, we're talking about PIA and risk management, and we need for sure, I mean, to discuss together on how what we consider to be a good PIA and how do we define the different steps for a PIA. So I think there is also need to have dialogue, in fact, with also the business. And I know that at the CNIL, we start to work with the MEDEF and APEX, so that's business federation, about that, in fact, about implementing the rules concretely with the business.
Okay, that's already long attachment.
Sorry, so that's all. So just to say that it's a collective solution. I mean.
Perfect. Karolina.
Thank you. I would mention two things. Some kind of a new trialogue now between the DPAs, businesses, and the Commission, trying precisely give some guidelines, facilitate the implementation, making use of the regulation, and using, I would call it, soft law instruments provided for in the regulation, which are provided for, in particular, to facilitate the application of the regulation to the businesses. So this would be my first point. And the second, setting up of an efficient, well-functioning European Data Protection Board, which from the bottom-up approach will be assuring this harmonized application of the regulation within the European Union. And let's not forget that here within the board there's a data protection authorities, which to some extent, because we were speaking so much about all these opening clauses on the national level, but they will be asked to give their views on new drafts legislation in areas which affect rights, fundamental freedoms of the citizens on the national level. So there will be this harmonization in the application of data protection laws in the European Union will be coming from very different directions. So again, two elements.
Okay, thank you. And Mr. Lynch, can you summarize it as well?
Yeah, I'll try and do it in the spirit of a tweet, where you don't have to form full sentences, which is great for me. But I think what I jotted down was drive for consistency, remove uncertainty, now please.
Okay, we have 15 minutes of this panel still left, and I would like to open the floor to all of you to ask the question to the panelists or to give the commentaries about the challenges that we have at the moment.
There's microphones in the middle row.
Do we have anybody who shared the microphone? Yeah, I can see Stuart Dresner trying to ask. Can I ask? If I can ask all the people to introduce themselves, where everybody knows Stuart, but probably there are some people who see Stuart for the first time.
Okay, Stuart Dresner, Chief Executive, Privacy Laws and Business. My question is to Karolina. You mentioned that the European Commission will facilitate the work of the Data Protection Board, and we know that the European Data Protection Supervisor's Office is going to provide the Secretariat. So how will your two bodies work together to make it a well-functioning body where the national authorities can get together and provide the guidance that companies need?
According to the regulation, the European Data Protection Supervisor will provide for the Secretariat, but which will be fully independent with all the Chinese walls and under the guidance of the future chair of the board. And how we will work, as usual, perfectly, smoothly cooperating and enjoying presence of Mr. Wiewiórowski, for example.
Right, thank you.
Well, I can add only that we started the practical cooperation on how to deal with the day-by-day organization of such a cooperation between the EDPB and one of the members of the EDPB who at the same time provides the Secretariat. Okay, I see there's a question in the end and then we have another one.
Gilles Deveau, I'm consultant. Could we envisage to have a consistency spreadsheet between the old directive the various work packages under the old regime, the new text, and the new recommendations being issued under the new regime.
Okay. Is there anybody who wants to answer the question like that? You mean the score sheet, like the comparison between what was in the directive and what is right now in the regulation?
Correct. What text will die, what text will subsist, and what text will, from now on, be considered as valid?
Well, we have the problem to understand precisely the meaning of the question.
All right, forget it.
No,
Obviously, there will be comparisons between the directive, the presently applicable Directive 95, and the General Data Protection Regulation, if it's your question, but I'm not 100% sure whether I understood correctly your question.
Okay, we'll take it aside.
Okay, and we have a question here in the first row.
Thank you. Winfried Feil from the German Ministry of the Interior. I would like to encourage all the actors to take over the idea of Mr. Hornung to provide some kind of database which has as a content all the lawmaking that will be going on in the next 2 years. Right now, heavy lawmaking will be taking place in Germany. We have to change hundreds of laws on the national and maybe even thousands of laws on the regional, on the local level. And probably in other member states the same will take place, maybe not to the same extent. So it will be very, very interesting for us to compare how the opening clauses, I've counted 60, others have counted 40 or 50, and the vague clauses, maybe even implicit opening clauses. So there will be a lot of lawmaking going on the national level in the next 2 years. And my fear is that fragmentation will be even worse than it is now if we do not check, meanwhile, how all these opening clauses are implemented on the national level.
Thank you. Can I ask Timothy Kirkhope and Florence Raynal to answer this question, because it's partly directed to the countries. What shall the countries do in order to show what is the challenge on their level?
Well, I think that's a very good question, because, of course, we do have different forms of legislative response in different European countries. So that obviously we all know that we have to implement, and we also know that as far as possible we need to implement in a way that is completely consistent across the board. That would help the larger companies, for instance, who've just said, you know, they're having to deal in so many different jurisdictions. It's rather a relief for them to see 28 countries that are going to have exactly the same situation in terms of protection and requirements, obligations on them. But there are differences, perhaps not in terms of the intent or the implementation itself, but there are differences in the legal systems which will apply, particularly in a federal structure like Germany, and indeed in other countries where there are certain requirements. And that may well have an impact, particularly, I think, in relation to the matter of access to a redress and so on, where there may well be some complications of a legal nature. And I think those things, we have this time now for implementation. I fully agree with you. We need to be very, very sure that we are cross-checking and trying to determine whether there are going to be difficulties here, whether that would ultimately cause a problem to delivering what is clearly an obligation. So I think you're right, and I think that's a very good point. And finally on that, I mentioned a fast approach, and I thought smart legislation for the future. That also applies in a lot of our countries, some of whom have got secondary legislation processes which don't require complicated and long-term debate and discussion, But of course that also then impinges on the arguments of whether there should be debate, particularly in implementation as well, in those countries.
Do you want to also?
Yeah, just to stress that it's a very, I think, a very valid point, very relevant one. I don't know if you heard, but we had at the French level a law that has been passed recently that in fact contains privacy provision, and there was a long debate about the articulation with the regulation that was coming in. And so, in fact, we had a very good relationship with the government, but also the Parliament, just to make sure that there is no overlap and that there is a good articulation between this project of law. That was about the CNIL power, that was also new rights for the data subject. And I guess that we need to be vigilant. I mean, we need to keep on being cautious about what's going on at the national level in order to avoid as much as possible this inconsistency that was the purpose of the revision of the directive. And I guess it's also why it's so important to have this national aspect in the EDPB. And that was a very strong discussion that we had for the whole discussion on the regulation, was this balance between national DPA and the European level, and not to create also a monster with the EDPB, too centralized, to Brussels, and also to make sure that there is a right balance with national DPAs that can also bring this kind of thing and make sure to monitor and to make sure that there is still consistency at national level. If you cut this line, if you don't have any more link with the national level, it will be terrible in terms of implementation. So that's why the core of the EDPB is the national DPAs, and that we need to make it run. We need to find smart things, as you say, smart system, smart law, but also to make sure that we have this connection, because there is also connection in the rules themselves.
Let me say that we have one practical demand right now to find out the database, or at least the list of those laws that have to be changed in different countries. Well, I have to say also that neither the parliamentarians of the European Parliament nor the data protection authorities are proposing such a list at the moment. These are the governments who works on it. So maybe that's also a kind of call from us to the representatives of the government. Apart from German government, we have also the representatives of the other governments here in the room. Maybe we can give the good example of the list of the legal acts at the moment that we are expecting to be changed in our country. Well, I know that if it comes in Estonian or Greek, it may not be easy to read it, but at least we will be able to compare this list and to go to them. Okay, we have another question here in the second row.
Thank you. I'm Hugo Zalberberg. I'm a student in Master in Public Policy, and I'm also a member of a research center at the Institut Mines Telecom based on personal data. My question is, you've talked a lot about how we get ready, Europe gets ready for this new regulation. And I'd like to ask about how other countries, other companies can get ready for it. So how do you see the work in the 2 years that are coming of outreach, of explanation of this new regulation, so that countries, companies, and other organizations can understand this framework and try maybe to anticipate how it's going to be implemented in Europe, so it's better compatible in the spirit of compatibility with other frameworks?
And can I then direct this question to our representatives of academia, because you will be explaining that as well, and to the business, what shall be then educated and explained?
Well, I think that's basically a practical question for explaining it, and probably not the job of the academia, because I have certain views on the content of or the meaning of certain provisions, but unfortunately those are not binding upon companies like Microsoft. So we need to have DPAs and the European Data Protection Board there doing this job.
But they have to learn from something.
Yeah. Well, I'm happy to provide my opinions, but just to give you one, to give you one more point, I think that these 2 years, and it has rightly been pointed out, are so crucial because once the regulation is in force, we need all these opinions, best practices, and so forth already in force. Okay, so I mentioned CCTV earlier. Okay, so the regulation is completely silent on CCTV, for example. Okay, so in Germany we do have a very precise provision on CCTV. It's very strict on transparency, for example. So the UK has a code of conduct, as far as I know, and no statutory provision. So what do those countries and those shop owners now do with CCTV, okay? And those shop owners need to know that before the 2-year transition period. And so we need opinions on that from Europe. And the problem is, as I mentioned earlier, that those opinions will be subject to judicial review. And so in the end, it will probably be up to the ECJ to tell us what this regulation means for CCTV operators. And the problem then is that if we collect ideas like CCTV in this room, if we collect ideas for preliminary rulings for the ECJ, we easily collect hundreds of ideas in like 10 minutes in this room alone, okay? And so this is the problem we're going to face in the next years, I believe.
Thank you.
Yeah, sure. I interpreted your question as what outreach would the Commission, the DPAs, etc., do to countries, companies, individuals to help prepare them for the changes and make sure things are compatible and like. And so I guess I'm answering it from the other way around. Is like what would organizations like ours like to receive, and what sort of engagement would we like? And I think it goes back in part to what Florence said, is that there's a lot of work to be done, and particularly when you get down to the practical matters of providing guidance and of how certain things get implemented. I know that there's a desire from a number in industry to have a say in that and have input. Large organizations like ourselves, we're of course aware of the requirements, and breaks in 3 minutes. We're aware of the requirements, and we've got the resources to kind of stay in touch, and we've got relationships in many countries and all that sort of thing. But I imagine that there's a second and a third tier of organizations that don't have that, may not be fully aware. And so I think there's a combination of direct engagement, which in some ways will be requested from companies like ours, but then also what's the broad reach communications to make everyone aware, including the data subjects themselves, as was pointed out earlier.
Thank you very much. Thank you for the questions. And I would like to ask Serge to summarize the discussion.
Well, summarize is a very, very difficult task, but I can add a layer of difficulty. And in the end, also, there is the judge that will have to interpret finally, actually, what the directive will mean in a certain situation. So there still is that uncertainty that lies before us. And on this positive note, I would like to close this session. I thank the speakers very much. It was very lively. Thanks to the public, thanks to the organization, and I hope you will enjoy the sequel of this consequence, this conference.